Emily currently serves as the co-chair of the ISBA Diversity and Inclusives Committee. She serves on the Iowa Supreme Court Interpreter Advisory Committee for many years. Emily regularly utilizes language interpreter services in her work as an ALJ and a Department of Inspection and Appeals Administrative Hearing Division and Unemployment Insurance Appeals Bureau of Iowa Workforce Development. Her duties as a Deputy Director of Litigation at the Iowa Legal Aid included oversight of language programs, policies, and procedure. Emily currently manages the Iowa Department of Workforce Development UI Appeals Bureau. I'm going to turn it over to Emily for today.
Thank you, Christy, and thanks to all of you who are attending via the web. I'm still getting used to this webcast procedure, so forgive me if I'm not looking directly into the camera and aren't as visible as you might like me to be. As Christy mentioned, I currently manage the Unemployment Insurance Appeals Bureau for Iowa Workforce Development. I've served in that role since July of 2015. As Christy accurately mentioned, I previously served as an administrative law judge for both Iowa Workforce Development Unemployment Appeals Bureau and the Division of Administrative Hearings with the Department of Inspections and Appeals, where I presided over a wide variety of state administrative agency appeals. And many of you, or some of you, may have heard me previously give CLE presentations, top 10 tips for administrative hearings in general, or top 10 tips for administrative hearings before the Department of Inspections and Appeals Administrative Hearings Division. So some of those top 10 tips would, of course, apply to Iowa Workforce Development and Insurance Appeals hearings, but I'll try to be a bit more specific to this particular area, and you may hear some repeats of the same general tips. The materials that you all received were recently revised and updated due to popular demand. Many attorneys have utilized this basic outline since it was first prepared in 2007 by the former Chief Administrative Law Judge Dan Anderson. I, along with many other attorneys in the state of Iowa, attended CLE presentations that Dan Anderson presented utilizing the UI appeals and UI adjudication basics outline that he had prepared in 2007. We recently updated that outline, and that is part of the materials that you received today. I won't go through that outline bit by bit today. I will focus on the top 10 tips as the CLE materials, or the CLE promotional materials advertised, but each of you have this updated UI appeals, UI adjudication basics outline for future use when you handle unemployment insurance appeals for your clients, whether your clients be claimants or employers. So first, some basics about, I'll use the word, or the acronym UI appeals is much easier to say than unemployment insurance appeals from now on. Some very basic items. Either a claimant, who is the person who wants unemployment benefits, or the employer, who typically does not want the individual claimant to have unemployment benefits. Either of these parties may appeal from an initial adjudication decision that either grants unemployment benefits or denies unemployment benefits to a claimant. So both the claimant or the former employee and the employer or the former employer of that individual have the right to appeal to the Unemployment Insurance Appeals Bureau of Iowa Workforce Development. The UI Appeals Bureau typically handles 14,000 to 15,000 appeals per year. We currently employ 15 administrative law judges, or ALJs, So 15 ALJs handle those 15,000 or approximately 15,000 appeals per year. Each ALJ handles between 20 and 30 appeal hearings per week, of course depending on the volume at that particular time of year and the experience and schedules available for each of the 15 ALJs. These unemployment insurance hearings are held on the hour, almost every hour of the day. So that gives you a basic idea of the volume of cases that each individual ALJ hears on a daily and weekly basis. The deadlines for issuing decisions in these appeals is very quick. Our general guideline as set forth by the U.S. Department of Labor requires us to schedule the appeal hearing, hold the hearing, and then issue the decision within 30 days of the date the appeal is filed. That's our general guideline. So what does that tell you? These all happen very quickly, especially if you're used to doing other types of general practice, civil litigation, or even criminal work. 30 days from start to finish is a pretty quick time period for this type of an administrative hearing and decision to begin and end. So all that being said, my first top 10 tip is note deadlines. The deadline to appeal the initial adjudicator's decision is 10 days. And that 10-day deadline is jurisdictional. In other words, if you don't file the appeal, whether you're representing a claimant or an employer, the Appeals Bureau has no jurisdiction to hear the appeal. So I can't emphasize that point enough. 10-day deadline to appeal, and timeliness is jurisdictional. You'll find a paragraph or a section on that point in the materials that you were provided. The appeal must be received in the Unemployment Appeals Bureau as an email, via fax, postmarked within those 10-day periods if you send it via regular mail, or you can file the appeal online. So there are several different ways to meet that very tight 10-day deadline. The online appeal form would be the recommended way to file an appeal because the online appeal form includes a number of prompts, for example, requesting an interpreter and the language needed, whether or not you want an in-person hearing or a telephone hearing, and the online appeal form includes other additional prompts to make sure that you're providing all the necessary information to allow us to process your appeal. So that's the recommended way to file an appeal, but you may also file the appeal via regular mail. Just make sure that postmark date is within the 10-day deadline, or via fax, or as an email attachment to our UI Appeals help desk. All of the fax number and these forms can be found on the IWD website under UI Appeals. So after you've noted the deadline, you've made the decision whether or not to appeal the underlying decision, whether you represent a claimant or an employer. You've filed your appeal. Then, this may seem very basic, but it's very important to make sure you open and read mail from IWD right away, because the hearing notice would be the next piece of mail you receive, and yes, we still send those out via regular U.S. Postal Service mail. That hearing is probably scheduled between 10, 14, maybe as long as 21 days out, but it will be scheduled very quickly. I'll go back to the first top 10 tip of how filing your appeal. Because you now know that the hearing will be scheduled very quickly and that the UI Appeals Bureau is under a tight deadline to hear and decide your appeal, It would be helpful if you provide dates you are not available within, say, the next 20 to 30 days, and or dates you are available during those days, to make sure that we don't schedule the hearing when you or an important witness are not available. So that's another helpful bit of information to provide. If you request an in-person hearing, which is both parties' right to do, either the claimant or the employer, the appealing party or the non-appealing party may request an in-person hearing. If neither party requests an in-person hearing, then the hearing will commence by telephone. At least 90% of our hearings are conducted via telephone. So all of the ALJs are accustomed to assessing credibility via telephone, accepting and submitting exhibits on the telephone hearing, and managing the direct examination and cross-examination of witnesses via telephone. So there's really no clear advantage or disadvantage one way or the other, whether your hearing be conducted by telephone or in person. It's purely a matter of preference, and if you and your client want an in-person hearing, you are certainly entitled to an in-person hearing. If you have not requested an in-person hearing in your appeal, then the notice you'll receive will be for a telephone hearing. It's very important to read the notice of hearing, decide whether or not you do indeed want a telephone hearing, which, as I said, is how most of these hearings are held. It's very important that you follow the directions on that notice of hearing. And yes, this may sound very basic, but attorneys make errors as well as unrepresented or pro se claimants and employers. You must register your telephone number with the Unemployment Appeals Bureau. The instructions for doing so are found on the front page of our notice of hearing on the right-hand side. The telephone hearings are conducted by the ALJ calling each individual participant who has registered, and then that entire process is recorded and the entire hearing is also recorded. So the ALJ with the UI Appeals Bureau handling your hearing must know the telephone number where you and or your clients are to be reached at the exact time on the exact date that the hearing is scheduled. Many people believe that the UI Appeals Bureau already has their telephone number because of any previous interactions with Iowa Workforce Development. That is not true, and definitely not necessarily true. So it's very important that you follow the directions on the notice of hearing. Even if you filed an appearance, even if you provided your telephone number in your appeal, to follow those directions, call in and register your telephone number and the telephone numbers of any other witnesses you want to participate in the hearing with the UI Appeals Bureau. And then and only then will the ALJ know that you intend to participate, and the ALJ will contact you on the date and at the time scheduled for that hearing. It's helpful for the ALJ to know the number of witnesses who might be participating in a hearing. So even if all of you, your client's witnesses, will be in one conference room during the hearing, which, yes, of course, commonly occurs, it's helpful for the ALJ to know whether or not there's 1, 2, 5 witnesses participating in the hearing, and it's also helpful to have the full names and job titles of those witnesses. So when you're calling in to register your name and telephone number and perhaps your main client or main witness's name and telephone number, it would be helpful to list all of the other witnesses. It will help make the hearing much more efficient if the ALJ isn't asking for each person's name and the spelling of each person's name and so on, but only confirming that information. And it also helps with scheduling to make sure that that ALJ knows ahead of time, whether or not there are 5 witnesses for any particular hearing or 1 or 2 witnesses. As I mentioned before, each ALJ has several hearings scheduled a day, and those hearings are typically scheduled to last an hour or less. So if your hearing might last more than an hour, that's another reason it's good for our office to know, and then we can do a little juggling to make sure that your hearing proceeds as completely and fairly as possible without inconveniencing other claimants and employers who have hearings scheduled for the same day. After you receive the notice of hearing, you're preparing for the hearing, you're gathering the evidence, you're deciding which witnesses to call. If you are, in addition to registering your witnesses and your own telephone numbers, decide on any exhibits that you want to submit and submit those to our office as soon as possible. Exhibits can be submitted via email, via fax, via regular mail. Sometimes they're submitted via all of those methods to make sure that we receive them in time. It's also helpful if you would send the exhibits to the other party. For example, if you're representing the employer, presumably you know how to reach the claimant since he or she was your client's former employee, and or you would be able to, you would see that the claimant's address on the hearing notice. Conversely, if you are representing the claimant, presumably the claimant knows how to contact his or her former employer because of the previous relationship. So it makes things move along more smoothly if you provide any and all exhibits you're providing to the UI Appeals Bureau to the opposing party. Hearsay is admissible in administrative proceedings, so any and all exhibits, can be submitted. The individual ALJ will decide whether or not each of the exhibits you submit are actually admitted into the record during your hearing. But as a general rule, hearsay is admissible in administrative hearings, and in particular in unemployment insurance appeal hearings. So we receive text messages, we receive Facebook posts, of course we receive copies of written warnings, copies of employee handbooks, general policies, procedures, disciplinary actions. So all of those items may very well be very relevant and will assist the ALJ in developing the record as we are required to do, and in making a full and fair, informed decision in your case. So prepare for the hearing, and as I mentioned, you don't have much time to do so because the hearing might be scheduled within 10 days or 2 weeks of the time you filed the appeal. So the sooner you can gather all your evidence and decide on all your witnesses, the better. If you need an interpreter for your hearing, please let us know that information. If you know that information at the time the appeal is filed, please include it. In the online appeal form, as I mentioned, there's a prompt for, do you need an interpreter, yes or no? If the answer is yes, then there are other prompts for the language that you need. What we'd also ask you to do is to give us the country of origin. For example, if the language is Arabic, it's helpful for us to know whether the country of origin is Sudan, for example, or Iraq or Iran. It helps us make sure that we obtain the best interpreter for your clients' language access needs. If you learn later that an interpreter is needed for the hearing, please contact our office, and you'll find the telephone numbers, fax numbers, the UI Appeals Help inbox email address on that hearing notice. So the sooner you can notify us that an interpreter is needed, the better. and we will make sure we arrange for an interpreter for that hearing. If your client is hearing impaired and needs an interpreter in American Sign Language, that's very important for us to know as soon as possible as well. That we don't need ASL interpreters as often as we need language interpreters, but we have used a few in the recent past, and we certainly will make sure that your client has the interpretation services he or she needs for the hearing. Make sure that you participate in the hearing, which again may seem very basic, but you'd be surprised how often this might happen. In other words, make sure you and your clients and or your witnesses are available on the date at the time the hearing is scheduled. The ALJ will call each participant who's registered in our system, and we'll make that call, at the time scheduled for the hearing or within 5 or 10 minutes of that time scheduled. So it's important that each person be ready to answer the call when the ALJ makes that call, to all of you who have dutifully registered the proper telephone numbers for the hearing. From time to time, a person isn't available. Maybe one of your witnesses is on another call or was called away from the phone momentarily. In those cases, the ALJ will leave a message and try to make that call again. You can sequester witnesses even in a telephone hearing. It's important, of course, to make that request, as comical as that may seem. But you can make that request at the beginning. From time to time, especially if you have several witnesses and you have a business to run, if you're representing employers, or claimants, witnesses, have other things to do and don't necessarily have the time to be present for an hour-long hearing. It'd be helpful for you to let the ALJ know the order that you'd like to call the witnesses, and or let the ALJ know of any time constraints one or more of your witnesses have, so the ALJ can perhaps call one witness, receive that testimony, and then release that witness after both parties have had the opportunity to ask that witness's questions and the ALJ has had the opportunity to gain all necessary information from that person. And yes, we can sequester witnesses if we're not calling that witness until it's time for his or her testimony. But it's important to make that request at the beginning of the hearing, because the ALJ will otherwise just call all the participants listed for that hearing at once and then sort out the order of witnesses later. It's important to have the witnesses with firsthand knowledge of the situation. If this happens to be a discharge for misconduct, then it's important for the ALJ to hear from the individuals who are actually involved in the incident, in the action or inaction of that claimant that led to their discharge from employment. Yes, it's very helpful to have the HR person or someone who might know the basics of the employment, first date, second date, or first date of employment, last date of employment, job title, full-time, part-time, those basic questions that any of you who've participated in UI appeals hearings will recognize. But it's also important to have that frontline supervisor and or coworkers or others who might have firsthand knowledge of that final incident, the incident with the action or inaction that led to the end of that person's employment. If it's a voluntary quit situation, similarly, it is important to know to have the person who was involved in the end of the employment, that person with firsthand knowledge. So whether that's the supervisor or the HR person or the other whoever it might be in that particular employer's business, who would be able to testify to the exact circumstances of that person's quit. How did the person communicate their intention to quit this employment, for example? If it's a layoff, it's very important to have the person with firsthand knowledge of that particular circumstance as well. As you can imagine from the outline you received and/or the terms I'm using, the vast majority of our hearings involve either a termination that's allegedly discharged for misconduct or a voluntarily quit situation. We also hear a number of cases of whether or not the individual is able and available for work, and in those cases, similarly, it's important to have the individuals who had the conversation with that claimant or former employee or a current employee and would know whether or not that person is able and available for work or what circumstances led the employer to believe that that employee was not able and available for work. In those type of cases, documents are typically very important. What medical information or releases did the claimant provide to the employer? What, if any, often email communications, as I mentioned before, text messages can be very useful these days in these cases, or other types of social media information are sometimes very important in any type of a discharge, a voluntary quit, or another type of unemployment case. As I mentioned, the vast majority of our cases are held over the telephone, but if you want an in-person hearing, you are certainly entitled to an in-person hearing. We currently schedule in-person hearings in several locations around the state. These locations are specified in an administrative rule. They include Des Moines, and as you can imagine, we're located in Des Moines, so it's very easy to have an in-person hearing scheduled in Des Moines. We also hold in-person hearings in Council Bluffs, Cedar Rapids, Davenport, Waterloo, Sioux City, Spencer, Dubuque, Decorah, Fort Dodge, Mason City, Ottumwa, and Burlington. The in-person hearings, again according to administrative rule, are scheduled at the closest location to the non-requesting party. So, in other words, if the employer requests an in-person hearing, the in-person hearing is scheduled at the location closest to the claimant. Thankfully, most of the time, it's the same location. The claimant and the employer are both located in or near Cedar Rapids, for example, or Ottumwa, or Burlington. As you can imagine, to conserve our scarce resources, in-person hearings are not scheduled every day in all of these locations. The ALJs are typically scheduled to make a visit to one or more of these offices several times a year. So if you request an in-person hearing, say in Waterloo or Ottumwa or Sioux City, you may be waiting much longer than that 2-week or 3-week period that I mentioned earlier. Your in-person hearing may not occur in one of these locations around the state for 2 to 3 months. So that's another consideration for your decision whether or not to request an in-person hearing or a telephone hearing. From time to time, a party who had previously requested an in-person hearing changes his or her or its mind and then requests a telephone hearing. And that's perfectly fine. Don't ever worry about changing from an in-person hearing to a telephone hearing. That can easily happen and does happen on a somewhat regular basis. For these in-person hearings, it's very helpful to let us know dates you are or aren't available. It's too bad for a party to have to wait 2 to 3 months for their hearing and then learn at the last minute that the case needs to be rescheduled because one or more essential witnesses or sometimes the attorney representing the parties have schedule conflicts and are not available for that hearing. So we'd prefer, of course, to schedule every hearing once and only once and meet our deadlines as mandated by the U.S. Department of Labor for each and every case. Knowing that that can't quite happen 100% of the time, we do our best, and we'd appreciate your help in doing our best to make sure that hearings are scheduled, held, and decided in a timely manner. The next tip should go without saying, I hope, but respect the judge, the administrative law judge, and the hearing process. The UI appeals hearings is what's often called the second step in the process. The first step in the process is what we call a telephone interview. It's a very quick 3 minutes, maybe a little bit longer, telephone conversation, but it is an interview between the parties and a person, workforce development informally called a fact finder, person who's called a workforce advisor, but an individual who will quickly take the information and make that initial decision whether or not the claimant is allowed or denied unemployment insurance benefits. That's the decision that you have 10 days to appeal. The appeal hearing with the ALJ is a more formal process, even though it's still mostly over the telephone. Respect the judge and respect the process. Behave as if you were in a court proceeding. The hearing is recorded from beginning to end. The witnesses will be placed under oath. The exhibits will be admitted. As I mentioned, hearsay is admissible, but the exhibits should be numbered, identified, and then the judge will reference those exhibits if they are admitted, and be helpful if the parties would reference the exhibits by the same exhibit numbers. Administrative law judges in unemployment insurance appeals have a special duty to develop the record. We're reminded of this over and over again by our higher authority, the Employment Appeal Board, but also by the Iowa Supreme Court and Iowa Court of Appeals decisions, and occasionally by district court decisions. I'll remind you of the appeal process. That's my the last of my tips. But remember, and please prepare your witnesses for these hearings. The hearings are an administrative proceeding. Witnesses are under oath. Only one person can speak at a time. And the administrative law judge will take an active role in this hearing. That's where the unemployment insurance appeals hearings differ somewhat from the previous work that I did in a Department of Inspections and Appeals, and that you may experience if you're an attorney who, in general practice, who handles administrative hearings in a wide variety of forums. So don't be at all surprised if the unemployment ALJ takes an active role in the hearing. That's because they're all very much aware of their duty to develop the record. So even though you as an attorney are representing your client, the ALJ will ask the initial questions of your client and of the other party. So the ALJ will ask those initial, what was the first day this person worked, what was the last day he or she worked, what was the type of job, and so on, and who made the decision to end this person's employment. So don't be at all surprised if the ALJ asks those questions, and please prepare your clients for that part of the process. We often run into very unsophisticated individuals, both claimants and employers, who participate in our hearings. So don't be at all surprised if the ALJ needs to ask a question more than once, or might simplify his or her language quite a bit to make sure that the individual understands the question and can answer that question. Don't be surprised if the ALJ has to occasionally admonish one party or the other to make sure that only the witness testifying at that moment is providing answers to questions and not receiving assistance from others who are sitting nearby or may have more or relevant or better information to offer, but is not the witness testifying at that moment. It's important that the ALJ asks the initial questions of each witness. Then the ALJ will allow you, of course, to ask your witnesses questions. The ALJ is also required to allow the other party to ask questions of each and every witness. So, and these are, of course, the right way to afford due process to all parties. And many of these processes are also mandated by the U.S. Department of Labor. So don't be surprised if each and every one of your witnesses is questioned by the ALJ, by you, by the other party. And from time to time, we'll allow another witness to ask questions if that helps to develop the record. The appropriate way to answer a question where if you're, say, for example, you're representing an employer and the HR representative doesn't know the answer to a question the ALJ asks, that witness can say, I don't know the answer to that question, but Mr. or Mrs. So-and-so may be the better person to answer that question. That would let the ALJ know that he or she needs to ask a different witness that question to gain that information, and keeps your particular witness from answering when it isn't his or her turn. The hearings are recorded, they are not transcribed, so that's one of the reasons it's important that only one person is testifying at a time. So later on, if the case is appealed, or if the ALJ or someone else is listening to the hearing recording, we'll know for sure that we're hearing all of the answers from Mr. or Mrs. Smith, and not one answer from Mr. Smith and then the next answer from Mrs. Smith, who is not yet testifying at that time. That may seem obvious to all of you attorneys, but you'd be surprised how often it happens. We have many very helpful, unsophisticated parties to our proceedings. All that being said, submit exhibits, make sure you have all the important witnesses and all the relevant witnesses. The key words are clear and concise. That's the best way to prepare for these hearings and the best way to prepare your witnesses for these hearings. As I mentioned, each ALJ has perhaps 5 or 6 hearings a day. An hour is typically scheduled for each of these hearings. So, and the ALJ has that duty to develop the record. So it's important that your witnesses be ready to answer questions and be ready to provide relevant information. But the judge will typically not need to hear excessive background information unless he or she asks for it and believes it to be relevant to your particular case. But it's important for you to prepare your witnesses appropriately to answer the question asked. And then if you believe there's additional relevant information that the ALJ has not asked, of course, it's your privilege and your duty to go ahead and make sure you ask your witnesses those questions to make sure that the ALJ has the complete picture. A side note on the hearing process itself, particularly if you are representing an employer, I always found it very helpful to hear background information about that place of employment, particularly in a discharge for misconduct case. It's the employer's burden of proof to show that this employee committed misconduct as defined in the statute and the administrative rules, and very recently clarified by the Iowa Court of Appeals, and that case summary is included in your materials, and as defined, of course, by the Iowa Supreme Court and Court of Appeals on various other occasions. It's important for the ALJ to know why the employer considered this particular act or omission to be misconduct for this employee at this place of employment. And that's where it's important to know some background, like what does your business do? You know, what is this particular employee's job title, job duties within this place of employment? Why was this particular action or action serious enough to rise to the level of misconduct? And now, as the recent Greenlee case stated, you, the employer, if you're representing an employer, bear the burden of proof and the duty to show that this act or inaction was intentional. Mere carelessness or negligence is not enough to show misconduct, but you must show that this act was intentional. And that's where your witnesses who witnessed the event are important, even if each witness is just offering a few details. That would be helpful to fully develop the record, and or exhibits that might show whether or not this action or inaction was intentional or did not rise to that level. Likewise, if you're representing the claimant, it's important to make sure the ALJ understands what your particular client did at this business, what were their job duties, what were they told or not told about what to do and what not to do, particularly in a misconduct case or where you believe your client was discharged for misconduct. Make sure that you are ready to ask the claimant, all those questions if the ALJ has not already asked enough questions to elicit the detail that you believe is important to this case. In a voluntary quit case, the claimant bears the burden of proof. So similarly, it's important for you, if you are the attorney for the claimant, to provide relevant background information to show, whether or not your client quit for good cause attributable to the employer. If you've handled very many of these cases, you're probably familiar with the administrative rules, and there are at least 40 different ways a person in the administrative, as listed in the administrative rules, that a person can voluntarily quit his or her employment. So when you're preparing for the hearing, and then especially when you're preparing your claimant client for the hearing, it's important for you to know, and then you to be ready to communicate through your questioning, if the ALJ has not asked these questions, why exactly did this claimant quit this employment or leave this employment, and how or why did they leave this employment with or without good cause attributable to the employer. So it's important to read these administrative rules and in your preparation for the hearing, and decide which of these 40 examples in the administrative rules fit your particular situation. If you're representing the employer, likewise, be ready to state how and when the claimant quit or left his or her employment, and then even though it's the claimant's burden of proof in a voluntary quit, the employer's information is helpful to show whether or not the claimant met his or her burden of proof. And there, again, hearsay is admissible, so if there are email messages, text messages, other types of communication, though that evidence is typically relevant, admissible, and helpful to the ALJ in making his or her decisions. After you've filed your appeal within that all-important 10-day period, you've received the notice of hearing, you've paid attention to the notice of hearing, you've followed the instructions on the notice of hearing, and then you're prepared and participated in the hearing, then you should receive the ALJ's decision within a very short time period after the hearing. Many of our ALJs issued the decision that same day or within a day or two after the hearing. You should certainly receive the decision within a week or 10 days is what most ALJs tell you during the hearing, and that is certainly true, but many ALJs issued their decisions within a day or two of the hearing. So there's a tight appeal timeline after the ALJ's decision, so it's important to read the decision and then make your determination whether or not you want to appeal that ALJ's decision. The deadline is a little bit longer. It's 15 days instead of 10 days. But note that next appeal deadline, will be found on the cover page of the ALJ's decision, and the next appeal is to the Employment Appeal Board. That appeal must be filed, as I mentioned, within 15 days. The appeal to the Employment Appeal Board can be transmitted the same ways that you could transmit or submit your initial appeal to the UI Appeals Bureau. You can submit that appeal via email, via fax, via regular mail, just making sure the postmark is within that 15-day period. Or there's also a paper form, appeal form, that you can find on the IWD website, and you can use that form as well. Your client can find those forms by visiting the local workforce development office as well. The Employment Appeal Board does not typically receive new evidence, so that's another reason it's very important for you to present your whole case at the ALJ level, appeal level. I don't think I mentioned this, but the appeal hearing before the ALJ is de novo. Any evidence that was provided or submitted at the initial adjudication or fact-finding level is not necessarily a part of the record at the ALJ level. That's one reason why it's important to submit any and all exhibits you want the ALJ to consider to the UI Appeals Bureau, and any and all witnesses must be present and testify under oath at the ALJ hearing. The Employment Appeal Board reviews all of the evidence presented. They actually listen to all the hearing recordings, again making it important that that process proceed in an orderly fashion. The Employment Appeal Board reviews all of the exhibits. They basically review the entire file that the UI Appeals Bureau, ALJ, used for that hearing. The Employment Appeal Board issues very timely decisions. They might affirm the ALJ's decision, which happens a majority of the time, but they may also reverse, or they may remand the case back to an administrative law judge for a new hearing. So don't be surprised if you appeal to the Employment Appeal Board, or EAB is the acronym we use for that agency, and you'll have another hearing before an ALJ. the Employment Appeal Board is sometimes very specific in their remands. They may remand to the same ALJ to further develop the record in a very specified way. We've received a few of those lately. Or the EAB, Employment Appeal Board, may remand specifically back to a different ALJ to hear the whole case again for one reason or another. So if you do appeal to the Employment Appeal Board, it's very important to look for their decision within a short time period and read that decision carefully, because it may be affirmed, it may be remanded in one of many specified ways, or it might be reversed, or it might be, sometimes they're affirmed but modified in a certain way. The next step of appeal from the Employment Appeal Board, if the Employment Appeal Board either affirms or reverses the ALJ's decision, is to the district court on judicial review. The appeal deadline for a judicial review is 30 days. So each step of the process is a little bit longer than the previous step. You may file any administrative agency appeal in Polk County District Court, as it is the seat of state government, or for an unemployment insurance appeal, you may file in the county where the employer is located. And we received district court decisions from judicial review proceedings in all areas of the state. So that's totally up to you and your client, whether you file your petition for judicial review in Polk County or in the district court where the employer is located, whether or not the employer is your client. The district court reviews the record as it existed before the ALJ. So once again, this is why it's very important to present your whole case before the ALJ. The other party in interest at the district court judicial review level is the Employment Appeal Board, along with the other party. So the ALJ, of course, does not participate in the district court judicial review level, but the district court typically reviews the entire record, so including the hearing recording, exhibits, the appeal file, any additional exhibits that may have been submitted to the Employment Appeal Board and or accepted by the Employment Appeal Board. And then the only way that new evidence can be presented at the judicial review level is if that new evidence could not have been submitted at the ALJ level. So make sure you prepare for that hearing that will come up very quickly and present all of your evidence at that hearing. And then if you choose to proceed further, then the next steps in the process will review and make a decision on that evidence. Of course, if you're displeased with the district court's decision, you may appeal in the usual way to the Iowa Supreme Court, and then your case may be decided by the Iowa Supreme Court or the Court of Appeals. One other very important point I would like to make, and this is where unemployment insurance appeals decisions differ from some of the other state agency appeals. ALJ decisions in unemployment insurance proceedings are public records. That means the ALJ's decision is posted on the Iowa Workforce Development website. I use some language in that section of the outline, which you'll find near the end of the outline. I think I used the word internet search engines. What I'll say is Google has found these decisions, and several individuals who are named in these decisions recently learned that Google found their decisions and are not happy about that fact. So just so you know, and all of you know, and can advise your clients of this fact, that the administrative law judge's decision is a public record. We're required to make them available to the public under 17A, and IWD, or Iowa Workforce Development, makes these decisions available to the public by posting them on our website. Of course, we do not control what Google does or doesn't do, or any other search engines. I don't mean to just name Google. It's just, that's what I've heard recently. So the information in the decision will be generally publicly available. So that's another fact to consider after you've heard me telling you to present any and all relevant evidence. Just know that the ALJ decision will be public and posted on the website. Now, if any of the information should not be public, and in some cases the files are sealed, and in some cases the decisions are sealed, very rare cases the decisions are sealed, and from time to time certain information is publicly available and other details are not publicly available. So if your case happens to involve a care facility, for example, and there's an incident of dependent adult abuse, that file will be sealed, and the decision will not include any patient names or resident names. Likewise, if it involves a child abuse situation, that information will be sealed, and the ALJ will take appropriate action to make sure that information that should not be public will not be made public. But it's important that you have that information. That concludes my remarks. You can contact me later with other questions, or I can now take questions if there are any. Okay. Now I get to look at all this. The only materials received is the basic outline. That was one question. I didn't prepare a document with the top 10 tips. You may receive the fact-finding worksheet. Just make sure you request that through our office, through the UI Appeals office. We regularly send those documents out to the parties. From time to time, these documents are not readily available to us because of another part of the process that we don't control. But when they are available, we do send those out as soon as possible. So that would be a great request to make when you're filing the appeal, or immediately after you filed the appeal, is to ask for those fact-finding documents. And just using that term is enough for us. That's the term we typically use as well. Some ALJs, well, the question is, what's my view on submitting a written position statement prior to the hearing? Some ALJs will consider it. Some might not be as likely as to consider it. What we rarely request, formal briefing or anything like that. What would be helpful, if you happen to know of a recent case that you want to bring to the ALJ's attention, please feel free to do that. If it's helpful for you to cite the rule or the statute that you believe directly applies to this situation. The ALJ may be, and probably is, very familiar with it, but might not necessarily be as familiar with it. And I have another question on here. I'm reading another question that was sent. What if the claimant wants to call a current employee of the employer as a witness? Is a subpoena required, and is the employer required to make the witness available? Yes, we have a subpoena process. Our current rule requires the person requesting that a witness be subpoenaed to say that they asked the person to appear without a subpoena and the person refused or was unable to do so. So it is important to provide that information. If you want to subpoena a witness who was a former coworker and a current employee of the employer, then make that request, and the information is specified in our rule. And it's also important to say that you tried to obtain or convince that witness to testify, but that witness could not do so or refused to do so without a subpoena. That was a good question. Oh, I answered that one. Pardon us while we scroll through the questions. The question is, I mentioned that ALJ hearings are de novo, and the fact-finding proceeding is not a hearing, it's a telephone interview. Witnesses aren't sworn, and they last typically only a few minutes. So I want to clarify that first, that the fact-finding level phone interview is not a hearing. So the documents submitted at the fact-finding level are not necessarily included as part of the record. When might they be? They would be included if you submit them to the Unemployment Insurance Appeals Bureau. From time to time, employers' participation in the fact-finding process, which I didn't go into because of time, but there's a whole section on it in the outline you received. The ALJ may try to access the fact-finding documents in those situations, but it's best, and the general rule is that if you want documents submitted for the appeals hearing, then you need to submit them to the UI Appeals Bureau, even if you submitted them previously at the fact-finding level. So are those all the questions? Okay, great. Thank you.